Good morning,
Let me know
everyone,
when.
and let me formally welcome you to day 3 of JI Week 2023. Good morning, Your Ladyship, the Honorable Chief Justice, Your Lordships, Justices of Appeal, Your Lordships, Justices of the Supreme Court, His Honor the Chief Magistrate and Resident Magistrates, Registrars, members of the Bar, staff of the Judiciary, members of the Cadre attending, and all other attendees. Welcome to this seminar on sexual and gender-based violence. It is my honor to introduce Judge Malcolm Simmons. His Honor Judge Malcolm Simmons is a UK qualified lawyer and judge. Currently, he's a resident judge and His Majesty's Coroner of the Falkland Islands, South Georgia, South Sandwich Islands, and the British Antarctic Territory. His full bio has been shared in the program, which has been circulated to you and which will be shared in the chat as well. So it's my honor now to hand over to His Honor Judge Malcolm Simmons.
Super. Thank you very much, Mr. Okay, so you've just been given a little bit of background about me. Let me just tell you a little bit more about what I've been doing. So at the moment, I'm the resident judge down here in the Falkland Islands. I'm also the coroner for this jurisdiction, which is a fairly huge jurisdiction that stretches from the Falkland Islands right down to the British Antarctic Territory. So we're quite a busy jurisdiction, even though we are fairly small in terms of population size. Since about 2017, I've been doing quite a bit of international consultancy work. So I've been working in Pakistan and in Asia, and predominantly recently in the Maldives. So I'm happy to chat with any of you about my experiences there. Between 2004 and 2017, I was an international judge. 2004 to 2008, I was seconded by the UK to the State Court in Sarajevo, where I was assigned to the war crimes and serious organized crime panels. And then from 2008 to 2017, I was a judge of the Supreme Court in Kosovo. And then I spent 4 years as the president of EU International Judges. And I've served on 2 judicial councils during my career. Because this presentation is being done remotely rather than in person, it's not quite as interactive as I would like, but I'm happy to answer any questions at the end. So sexual and gender-based violence, and I should apologize because I understand that the screen is not particularly clear at your end, which is probably the result of issues with bandwidth from the Falkland Islands. So sexual and gender-based violence, it's also referred to as GBV, gender-based violence, as VAW, violence against women, and SGBVWG, which is sexual and gender-based violence against women and girls. And different jurisdictions and organizations tend to use different terminology. For example, the World Health Organization uses VAW, and UNHCR uses SGBV. And it's SGBV that I'm going to be using during this presentation. There is sometimes a tendency to think that sexual and gender-based violence is limited to armed conflicts. It's not. The principles are of general application to all sexual assault allegations of the type that come before our courts, and we sometimes refer to them as domestic violence. And victims of sexual violence tend to be women and girls. Occasionally, the victims are men and boys. But because this type of offending predominantly involves women and girls, I will normally refer to them as the victims. So sorry, I just need to try and move this screen slightly. The Constitution of TCI enshrines the fundamental rights and freedoms of the individual. And those rights include, amongst other things, the right to life, liberty, and security of person, the right to the highest attainable standards of physical and mental health, the right to freedom from torture or cruel, inhuman, degrading treatment or punishment, and the right to freedom of opinion and expression, to education, social security, and personal development. And most fundamentally, the right to be treated equally. Now, your constitution may not actually use those precise words, but that is, those principles are enshrined within the constitution. And it's important to recall that these are not simply aspirations, that they are fundamental rights and part of your law. They're also human rights that are enshrined in international human rights instruments. And as we all know, that human rights are universal, inalienable, indivisible, interconnected, and ultimately interdependent. And everyone is entitled to all the rights and freedoms without distinction of any kind, be they based on race, color, sex, language, religion, political, or other views. And prevention of and response to gender-based violence is fundamental to the protection of human rights. Now, there are many international treaties and conventions that deal with discrimination and issues around sexual and gender-based violence. And I'm only going to mention a few of them. And these are treaties and conventions that have been extended to TCI. And they include the Convention on the Elimination of All Forms of Discrimination Against Women. And this sets out discrimination against women as a violation of their human rights. And it frames sexual and gender-based violence within the overall context of discrimination. And it expands the definition to include specific acts of sexual and gender-based violence that often amount to torture or cruel, inhuman, or degrading treatment. You also have the Covenant on Civil and Political Rights. This is particularly important in my view, because certainly as a judge, because it includes the right to equality before the courts and the right to a fair trial. And I will keep coming back to that during the presentation. You also have the Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment. And this recognizes sexual and gender-based violence as a form of torture and discrimination, irrespective of the situation in which the violence takes place, whether in armed conflict or peacetime, in the home, in the street, or indeed in places of detention. You then have the Convention on the Rights of the Child, which sets out the right of the child to be free of violence and sex-based discrimination. And you have the Protocol to Prevent, Suppress, and Punish trafficking in persons, especially women and children. And this aims to prevent, combat human trafficking, protecting and assisting victims, and promoting cooperation among state parties. Now, states generally have an obligation to respect, protect, and fulfill women's rights to live life free from violence. That includes the following obligations of state actors. And these are obligations on the state. The obligation to refrain from committing acts of gender-based violence against women and girls, abstaining from enacting or implementing laws and policies that directly or indirectly deny women and girls equal treatment in law and practice. Exercising due diligence in preventing, investigating, punishing, and redressing harm. Ensuring an environment in which sexual and gender-based violence is prevented and access to legal and social services are ensured in cases where violence occurs. Now, different approaches are used to incorporate international norms into domestic law. In jurisdictions where treaties become part of domestic law once ratified, the judiciary can enforce them directly. Other states required a distinct step for international obligations to be incorporated into domestic law before judiciary can rely upon them. However, even when international law instruments have not been formally incorporated into domestic law, the judiciary can still and should consider using international norms and standards as authoritative guidance in interpreting relevant provisions under domestic law. So what is the role of the state in enforcing international law in domestic courts? Well, firstly, prevention and protection. State agencies should prevent further violence from recurring and ensure effective protection throughout the criminal process. One of the reasons women and girl victims engage with the criminal justice system is to stop the violence and prevent violence from recurring and indeed escalating, as well as to prevent threats of violence, intimidation, and harassment. Their protection needs can be both urgent and long-term, as well as situational. And once the victim reports, you may experience specific threats and pressure to drop the case. And of course, during or throughout the criminal justice process may be subject to retaliation and continuing violence. Victim safety and empowerment is a central consideration in any judicial decision with respect to criminal protection orders, pretrial detention, and pretrial release. And of course, judges and other participants in the process should also give consideration to possible protective measures that the court could use during the court process. Right. The second obligation of the state in enforcing international law in domestic courts is investigation and prosecution. And the state must ensure that investigations or prosecutions are undertaken according to legal requirements in an effective and diligent way. And the third requirement is punishment and redress. Punishment must be adequate, effective, and dissuasive. And prosecutors and judges must be aware of their duties and responsibilities in enforcing these obligations that are imposed on the state. And I should also add, as well as considering the imposition of protective measures during trial, prosecutors and judges also have a role in creating enabling environments that allow women and girls to effectively participate in the criminal justice process. Now, basic principles for the judiciary. I suppose as a judge, I tend to sort of, in the past, I've focused on training of judges. Part of my presentation will be particularly relevant to judges. Other parts will be relevant to all participants in the criminal justice process, be they judges, prosecutors, defense counsel. Now, the Committee on the Elimination of Discrimination Against Women, they made a general recommendation, which is as follows. All judicial bodies are required to refrain from engaging in any act or practice of discrimination or gender-based violence against women. Seems quite reasonable. To strictly apply all criminal law provisions punishing this violence, ensuring all legal procedures in cases involving allegations of gender-based violence against women are impartial and fair, and unaffected by gender stereotypes or discriminatory interpretation of legal provisions, including international law. And I'm going to come back again and again to talk about gender stereotypes when dealing with this type of case. The recommendation goes on to say that the application of preconceived and stereotyped notions of what constitutes gender-based violence against women, what women's responses to such violence should be, and the standard of proof required to substantiate its occurrence can affect women's rights to the enjoyment of equality before the law, fair trial, and the right to an effective remedy. So that's just a reminder for judges just to keep a very close eye on the process to ensure that gender stereotypes are not being used, are not being allowed to be used, and that in this type of case, judges control the process perhaps more closely than they might in other types of trial. Bangalore principles, I know you're all familiar with this, but it's always useful every now and then just to remind ourselves of what they say. In terms of the way the judiciary approaches cases of sexual and gender-based violence, it's important to remember that in addition to constitutional provisions and laws, or whichever international treaties or conventions apply, the Bangalore principle set out the principles that are intended to establish standards of what are normally referred to as ethical conduct of judges. And we know that this talks about independence, impartiality, integrity, propriety, competence, and diligence. Importantly, it also talks about equality and treating parties, be they defendants, be they victims, equally before the law. And these principles are, as you know, enshrined in your constitution. Okay, so this is the classic definition of sexual and gender-based violence. And in case you can't read it particularly clearly, I'll just quickly read it. It's sexual and gender-based violence includes any act perpetrated against a person's will based on gender norms and unequal power relationships. Okay, so let's break this down. Sex and gender. Now, these words are often used synonymously. They are, of course, not the same. They have different meanings, and their interpretation and application in sexual and gender-based violence cases are important to understand. So, sex. Now, the keen lexicologists amongst you have probably already noticed that the word used in this classic definition is sexual and not sex. And I should say that the definition is understood to mean relating to sex rather than physical attraction or intimate physical contact between individuals. Perhaps at this stage, I can also say that this definition also uses the word violence, but in the context of sexual and gender-based violence cases, violence actually has a meaning beyond what might ordinarily, in ordinary language, be considered violence. And I'll return to these concepts in a moment. So let's deal firstly with sex. Sex is basically what we're born with. It refers to the physical or biological differences between males and females. It's determined by biology. Now, sex does not change without surgical intervention. So that is what is meant by sex. Gender is different. Gender, its meaning has changed over time, and in our societies continues to change. It would be fair to say that perhaps 20 years ago, gender did seem to have the same meaning as sex. They're now quite different. So gender is what society or our culture teaches us about how we should behave based on our sex. Gender is concerned with what it means to be a boy or a girl, woman or man, in a particular society or culture. That's understood to be the sort of the definition of gender. So gender refers to the social differences between males and females. It's determined by social factors, history, culture, tradition, societal norms, even religion. Gender in any given society involves the socialization of boys and girls, men and women, that determines roles, responsibilities, opportunities, privileges, limitations, and also expectations. Gender definitions can and do change, and we see that constantly within our own societies. Now, although certain characteristics of men and women are pretty much innate, our roles as men and women are socially influenced, and gender determines the roles, the responsibilities, the privileges, the expectations, etc. So these perceptions and beliefs are influenced by society and by tradition and by social norms. Gender norms usually impose restriction on women and girls in particular. Women usually have less power than men. In many societies, women develop or are given lower expectations of their rights, and they are often assigned particular roles. There are certain things that in some societies are expected of women. On the other hand, the rigid gender roles that are assigned to men are also fairly sort of pronounced. So, I mean, men are not expected to cry. They're not expected to, or they're expected to sort of look after their family, to provide for them financially. They are assigned particular roles within our society. You know, when a man has a mental health issue, you know, he's sometimes perceived to be weak when he wants to talk about it. So let me just give you some quick examples of the differences between gender and sex. Women give birth to babies, men don't. That's about sex. It's not about gender. Little girls are gentle, boys are tough. That's about gender. You know, there are some girls out there who are pretty tough, and in fact, a lot tougher than some boys. So that's what society imagines how girls should behave. You know, most building site workers are men. Again, that's a gender definition, because there are many women in our society now who perform roles on building sites. Okay. So that's just sort of a very broad definition of the distinction between gender and sex, so that we understand it going forward. Let me just talk about the victims of sexual and gender-based violence. And it's important to understand which groups within our society may be victims. Some organizations use the term survivor to describe persons who have been the subject of sexual and gender-based violence. Most jurisdictions use victim, and that's the definition that I will use. Victims are usually women or children, but they can include the physically or mentally disabled female and male members of society, economically disempowered people, junior staff, males and females, students, less privileged community members, minority groups, asylum seekers, and internally displaced persons. So persons within those groups could fall within the definition of a victim for the purposes of sexual and gender-based violence. Now, we've looked at sex and gender. Let's look at the other ingredients of sexual and gender-based violence. This is it. Sexual and gender-based violence, I've underlined, includes any act perpetrated against a person's will, and I've underlined that, based on gender norms and unequal power relationships. And that's also important to remember. Violence, will, and power are key ingredients of sexual-based violence. Will is also related to power relationships and inequality in those relationships. And I'm going to look at each of those components in turn. Violence. In essence, violence involves the use of force. The force might be physical, emotional, social, or economic in nature. It may also involve coercion or pressure. So we use the word violence, but in fact, we mean force. Force includes intimidation, threats, persecution, and other forms of psychological or social pressure. It involves not only physical force or a threat to use force, but includes other forms of coercive behavior. And this is particularly relevant in domestic violence type scenarios. And in a moment, I'm going to look at a little bit more closely at what constitutes violence in the context of sexual and gender-based violence cases. But let's look at will. Now, sexual and gender-based violence is an act, a forceful act against a person's will. And when we talk about will, we usually talk about consent. Now, consent means saying yes. It means agreeing to something. In cases involving alleged sexual violence, we are concerned with informed consent. An informed consent means making an informed choice freely and voluntarily by persons in an equal power relationship. Acts of gender-based violence occur without informed consent. In other words, even if the victim says yes, this may not be true consent because there is an imbalance of power, or because it's said under duress, because of a threat, because of a fear. So the will is very important to sort of look at the components and the key ingredients. Then I'm going to look at power. Sexual and gender-based violence occurs in situations where there is an imbalance of power. But what I suppose gives a person power? Perpetrators can have real or perceived power. And I'll give you some examples. And some of these fall outside of the context of sexual and gender-based violence cases, but I'm mentioning them because it's sometimes useful just to sort of understand, the context of the type of case that we're dealing with. So you can have social, peer pressure, bullying, leader, teacher, parents, that sort of thing. Economic, where the perpetrator controls money or the access to money. In some jurisdictions and in some situations, there can be political power that is used by elected leaders and even extends to discriminatory laws. Physical power, strength, size, controlling access or security in conflict and post-conflict zones. This power is often exercised by the police or the military. There's also sort of a gender-based perception of power, that males are usually more powerful or in more powerful positions than females. And sometimes age-related power. The young and elderly have the least power. There's the perception in those situations. And it's important to note that power is directly related to choice. The more power one has, the more choices are available. And the less power that one has, the fewer choices are available. And therefore, unempowered people have fewer choices and are therefore more vulnerable to abuse. So gender-based violence involves an abuse of power. In other words, unequal power relationships are exploited or abused. Now, I'm just going to repeat this because it is quite important. Sexual and gender-based violence refers to any act perpetrated against a person's will based on unequal power relationships. So, although power can be used for good purposes, power can also be used to dominate, to marginalize, to force other persons to act against their will, and to impose restrictions on other people's lives. I've been through the definition of power, and power relationships can be based on physical power, economic power, etc. And that's important to recall when we are dealing with particularly sort of cases of domestic violence. So I'm going to look at the forms of violence and the types of sexual and gender-based violence. Violence can be physical. It can be physical assault, beating, slapping, biting, burning, punching, kicking. It can involve a form of slavery. It can involve confinement. It can involve punishments for defying cultural norms. And physical violence can also involve, for example, female genital mutilation. Violence can also be emotional or psychological. And this can include verbal abuse. It can include confinement, forced marriage and child marriage, social exclusion based on sexual orientation or gender identity, denial of opportunities, and I'll come back to that, humiliation, manipulation, spousal confinement. So those are forms of emotional and psychological violence. And violence can also be sexual, harassment, rape, attempted rape. In some jurisdictions, it includes marital rape, so rape within marriage between spouses, child sexual abuse, online sexual abuse, sexual abuse as a weapon of war, something that regrettably I have come across many times, genital mutilation, sexual assault, sexual exploitation, trafficking, and also sexual violence that is based on sexual orientation. So those are some examples of sexual violence. But what about the following? We've got also denying girls their right to education, depriving women of inheritance, property, or land ownership, and giving boys and men preferential access to food or services. These are issues that often come up in post-conflict societies where there is a significant difference between the way that men and boys and women and girls are treated. There are also the harmful traditional practices. I've mentioned female genital mutilation, sometimes early or forced marriage, honor killings. In some jurisdictions, you will have dowry abuse. You may even have denial of education, etc. So those are just some other examples from other jurisdictions of the type of violence that sometimes women and girls will experience. So when dealing with sexual and gender-based violence, we have to have in mind the following: gender, violence based on gender roles, expectations, limitations; power, sexual and gender-based violence involves an abuse of power or a power relationship. It involves violence or the use of force, including threats and coercion. And force is not always physical force, and that's really important to remember. And that's why the sort of the standard definition of sexual and gender-based violence is sometimes misleading, because it talks about violence. And I think sometimes when lawyers look at this, they think, well, there was no physical violence, therefore this case does not fall within the classic definition of sexual and gender-based violence. In some cases, it will, and where, for example, there has been a denial of, or there's been confinement, there's been a denial of access to financial resources, etc., they would be covered under the sexual and gender-based violence definition. Also, when defining sexual and gender-based violence, have in mind informed consent. Sexual and gender-based violence is normally characterized by an absence of informed consent. And also have in mind human rights, that acts of sexual and gender-based violence are normal violations of fundamental human rights. So what are the root causes of sexual and gender-based violence? Well, these tend to be social norms and practices, including the roles, responsibilities, limitations, privileges, and opportunities afforded to individuals within society based upon gender. They can include male or society attitudes of disrespect or disregard towards women, a lack of belief in equality, cultural or social norms of gender inequality, a lack of value of women or women's work. In many societies, women are considered to be second-class citizens. They're considered to be not of, or their value within society is considered to be less than that of men. So possible contributing factors. Well, there are many possible contributing or perpetuating factors. And these include religion, culture, family beliefs and practices, alcohol and drug abuse, poverty, lack of services, activities, programs. General lawlessness can also perpetuate sexual and gender-based violence. Absence of inadequate laws against forms of gender-based violence, the failure of police to protect and investigate, the absence of or I should say, the failure of the prosecution authorities to investigate and prosecute cases of this type. Sometimes this type of behavior is perpetuated by the courts, failing to treat cases of this type with the seriousness that they deserve. Legal systems that silently condone gender-based violence. And then at the other extreme, of course, when you talk about societies in conflict, that sometimes there is a political motive to commit acts of sexual and gender-based violence, and that is something that I saw over many cases in the Balkans. Access to justice. Many women and girls who are victims of sexual and gender-based violence do not have effective access to justice. And when we talk about access to justice, what we're talking about is access to an effective remedy, an efficient and affordable process, the right to a fair hearing, and equality before the law. So this is what I mean when I talk about access to justice. Now, access to justice is a basic right. Everyone is equal before the courts or the tribunals. Everyone is entitled to a fair and public hearing by a competent, independent, and impartial tribunal. Everyone has the right to an effective remedy, including adequate reparation, or in other words, damages, for violations of those human rights. And these are all rights that are enshrined in the Constitution, and they are enshrined within the Bangalore Principles. But issues around sexual and gender-based violence are not just the applicable law. Everyone involved in the investigation and prosecution of sexual and gender-based violence should be aware of social as well as institutional barriers that victims may encounter in accessing the justice system. And these are really important because there's often a social stigma around reporting sexual violence. There's sometimes family and community pressure. You know, some victims simply don't have the understanding or knowledge of how to complain, what their first port of call should be. There's sometimes a lack of trust or fear of the criminal justice system. There's a fear of retaliation by the perpetrator. You know, in some rural communities, there simply isn't access to a justice system or to the justice system. You know, lack of legal assistance and victim support. Ineffective, insensitive criminal investigations. Sometimes victims don't want to enter the court process because they don't have confidence in the justice system, and they find the entire criminal justice process traumatizing. So they choose not to engage with the criminal justice actors, be they police, prosecutors, or the actual court process. And I should also mention here something that I have come across many, many times, and I'm going to return to this shortly, and that is the risk of over-reliance by the prosecutor and by the courts on physical evidence, i.e., it can't have been rape because there isn't any physical evidence. And I'm going to come back to that. So I'm going to look at each element of the sort of the principal elements that often impact a victim's access to justice. First of all, awareness of rights. If victims aren't aware of their rights, they will not know what protection or prevention measures are available to them. But it's not just about victims' awareness of their rights. Police, prosecutors, and the courts must also be aware of a victim's rights and how they should be addressed. The ability to access the justice system is also a huge challenge in some communities. When someone has been the subject of sexual violence, the first port of call is usually the police. Some women who report sexual violence are met with indifference and even hostility. In many communities, women face challenges that include access to alternative accommodation. So they've been sexually abused. Perhaps a partner has been physically violent towards them. Where do they go? There are insufficient shelters within our communities in order to support women who do choose to leave a violent relationship. Access to funds to seek legal advice. If a case goes to court, some women cannot access funds to travel to court. They may have children that require childcare. And if they are going to court, if they're staying overnight somewhere, sometimes they don't have anyone to look after the children when they are in court, giving evidence, when they are meeting with their lawyers. And sometimes if a woman brings a sexual assault case, she is shunned in her society. Even if she was raped or abused, in some places I found that the social opprobrium was directed not at the perpetrator, but at the victim of the violence. And sometimes traditional approaches to a woman's role in the family vis-a-vis her husband and society generally create tensions in terms of reporting. And some women who report domestic violence are even ostracized by their families. And I dealt with one case in Albania, where a woman had been systematically abused over a number of years by her very violent husband. And she finally plucked up the courage to leave him. And she went with her children back to her family. And her parents immediately put her in the car and drove her back to her husband. Because in Albania, it is dishonorable for the wife to leave her husband in those circumstances. And the family's view was that the wife should simply sort it out, and that it was a matter between her and her husband, and that there was no place for the family or for other agencies to become involved. It was a personal family matter. That is how it was perceived. And 3 weeks later, that woman was murdered by her husband. And I'll come back onto that because, in fact, she did eventually go to the courts, and she was let down by the courts. The court failed to put in place the protective measures that it should have done. And so the entire system let her down. Also, of course, we need a legal framework that conforms to international human rights standards. That's critical. There's no point in anyone reporting sexual or gender-based violence if we don't have the framework in place. Judicial and law enforcement processes have to be sensitive to sexual and gender-based violence cases. Often they are not. Barriers to justice in sexual and gender-based violence cases. There are three principal potential barriers to justice. These include barriers relating to the legislation, barriers within the justice system, and barriers related to access, including lack of awareness, practical issues, and possible repercussions. Some of those I've already dealt with. I'm going to give you some examples of each. Legislation. The absence of legislation addressing or criminalizing sexual and gender-based violence. In some jurisdictions, criminalization is based on the use of force rather than lack of consent. Therefore, prosecutor will say, well, if there was no force used, I'm not interested. I'm not going to prosecute. That fundamentally ignores the point that is enshrined within the Constitution and in international law, that this is about consent or lack of consent. In some countries, legislation only recognizes rape and no other forms of sexual violence, or indeed limits the definition of rape. Some laws are discriminatory, for example, relating to forced marriage, compensation given to the family rather than the victim in some cases. And I've even dealt with cases where the rape victim was even accused of adultery, and having been raped by a stranger, the husband divorced his wife based on adultery laws. Sexual and gender-based violence against men and boys is often not included in domestic laws. There may be no access to judicial remedies in countries where, for example, same-sex relations are criminalized. Police and law enforcement agencies are often ill-equipped to deal with sexual and gender-based violence. Cases are often assigned to inexperienced prosecutors, some of whom I have come across were clearly unsympathetic to victims in this type of case. And also, of course, we have situations where, where some judges are poorly trained in terms of dealing with sexual and gender-based violence. When I worked in Albania, again, one of the problems I encountered there were victims often didn't know who to report allegations to. They would go to police, some of the victims I spoke to said that when they went to the police station to report a sexual assault, they were simply turned away, told to go home. It wasn't a matter for them. Sometimes in some societies, it's very difficult. I mean, it's very difficult for any victim to describe in detail a sexual assault. In some societies, it's more traumatic. And I think some of the victims I have spoken to in some societies have found that it has been very difficult to describe to male police officers what has happened to them. Some police are simply ill-equipped to deal with allegations of rape. There are insufficient rape kits available. In Kosovo, where I worked, there were only sort of 2 rape kits available to police, one at one end of the country, the other at the other end. And so as part of my work in Kosovo, I made sure that not only were rape kits available in every police station, but that anyone wishing to report a sexual assault was able immediately, upon first reporting to police, to be given access to a trained police officer who would be able to take a more sympathetic approach and would understand how to deal with a traumatized victim and the evidence gathering process. The other thing I did in Kosovo was to make sure that we had in place judges who were carefully selected and trained to deal with sexual and gender-based violence. And that came off the back of a hearing that I went to where a woman who had been serially abused by her abusive husband was treated, in my view, very poorly by the judge. I sat at the back of that court, and she described how every evening he would come home drunk and would then proceed to beat her, sometimes beat her unconscious. And she eventually got the courage to go to police, and she left him. And the police initially were not very sympathetic. Eventually, a prosecutor was persuaded to take up the case, but that was only under international pressure. The case went before the judge, and the judge then accused the victim of being primarily responsible, because he said, well, you know, when your husband comes home drunk at night and then starts to basically slap you around, it's your responsibility to try and diffuse the situation. So maybe you should try and crack a joke or do something to try and change his mood. That was the approach of the judge in that situation. And it was at that point that we realized that we needed to do something fairly drastically to change the way that this type of case was dealt with in Kosovo. Anyway, I'm digressing. Challenges. I want to look at some of the challenges that we sometimes face when dealing with cases involving sexual violence. This is a typical question that is often posed in cross-examination. If it was so bad, why did you stay? Or if you're telling the truth, you would have left him. You know, you wouldn't have stayed in an abusive relationship. The reality is that many women who are in abusive relationships stay in those relationships. They may suffer from significant mental trauma, such as post-traumatic stress disorder, depression, and anxiety. They may feel socially isolated. They may have low self-esteem. They may have children. They may have no independent means of supporting themselves financially. So even if they left the husband, where would they go? What would they do? How would they survive, especially with children? And also, of course, the lack of shelters for victims of domestic and violence are also a significant problem. There are also common myths and gender stereotypes, and there are 4 common myths in my view. The first one is, well, she asked for it. In cases of sexual violence, a woman or girl's manner of dressing or behavior is sometimes considered to imply consent to sexual violence. Another myth, well, it wasn't really sexual gender-based violence. Rape is committed, some people take the view that rape is committed by a stranger with force or weapon. The real domestic violence is serious physical violence leading to serious injury or death. This wasn't serious, this was just a slap. It didn't really leave much of a mark. That's another common myth. A third common myth is, she wanted it. No woman would allow herself to be raped. Good women are sexually chaste. Real victims would fight back. I've heard that so many times in cross-examination where a defense counsel said, well, did you suffer any injuries? No, I didn't. Well, that would imply that you were consenting. And there are many reasons why women don't fight back. One is because of the risk that they would be overpowered. And we had a sort of a notorious case in England some years ago, where in the space of a week or two, one judge had said to a victim, well, if you hadn't consented, you would have fought back, and it seemed to imply that the lack of injuries suggested that she had consented. And then in a case a few days later, another judge said, well, if you hadn't fought so much, you wouldn't have suffered so many injuries. I think both of those judges left the judiciary fairly soon after making those comments. And that is an example of the sort of stereotypical behavior that regrettably we sometimes find within the judiciary. Now, the fourth example of a common myth is, well, she lied. Women who have had sex outside of marriage or have had multiple partners are not trustworthy. Victims make false allegations to seek revenge. And in some cases where you have rape within marriage, that the wife is lying to get an advantage in a family law case. I mean, that also applies where, for example, in a family law case, the wife may say, well, or the partner may say, well, my partner or husband was abusive, and that's why I'm leaving him, and that's why I want custody of the children. So, those are sort of 4 common myths that we sometimes come across when we're dealing with sexual and gender-based violence. And this is what I've just been talking about. Is it really sexual violence if there are no injuries? And along with the question of why the victim didn't fight back is the belief that if a woman or girl suffered sexual violence, medical evidence of her injuries will corroborate her account of what happened. Now, medical examinations, they may confirm sexual violence, but they can never exclude sexual violence. And it's quite possible that sexual abuse leaves no discernible physical trace on the victim. And there are many reasons why definitive medical evidence is not forthcoming in most cases of sexual and gender-based violence. Contrary to the myth that victims will immediately report such violence, this is not always the case. Delay in reporting, days, months, weeks, years, is quite common. And such delay in reporting may, of course, exclude the possibility of gathering medical evidence. But even where a medical examination is carried out soon after an alleged assault, there may be no findings. Some forms of violence, such as unwanted sexual touching, creation of pornography, oral sex, do not generally result in physical findings. Moreover, vaginal tissue is elastic, and full penetration by an object, a finger or even a penis, may cause no visible trauma. Redness or minor abrasions of mucous membranes may no longer be detectable within minutes or hours, and sperm of the perpetrator may not be found. And for example, if ejaculation did not occur, or if the victim took a shower, brushed her teeth, or even urinated. So there are explanations as to why physical evidence is not found. And I just repeat that while medical evidence may support a conclusion of sexual violence, medical evidence can never exclude the possibility of sexual violence. Now, consequences of gender stereotyping. If we fail to recognize the stereotypes, we risk, I suppose, firstly, trivializing violence perpetrated against women, shifting the blame from the perpetrator to the victim, exonerating the perpetrator, and contributing to the sort of overall oppression of women and girls in our society. And we need to think about how those involved in the criminal justice process might improve access to justice for victims, but also allow victims to give their evidence, to give their best evidence before the courts. So I'm going to look at the role of the justice system in sexual and gender-based violence cases. Case management. I suppose my first sort of rhetorical question is, how can case management be improved in order to deal effectively with sexual and gender-based violence cases? In my view, that we should assign prosecutors who are specially trained in dealing with this type of case. I already talked about deficiencies in the way police handle this type of case. We should have specially trained prosecutors assigned to the cases. We should also designate trained and experienced judges to deal with this type of case. Judges and prosecutors should be identified who possess the knowledge, skills, and attitude to deal with these types of cases. They should, in my view, be sensitive, compassionate, and empathetic. And designated judges should undertake regular training. We should also designate court times, appreciating that waiting in overcrowded waiting rooms increases distress and may even contribute towards secondary victimization. And this can easily be overcome by judges and by the parties in a case management conference discussing the potential challenges and setting the timetable accordingly. Courthouses should have sufficient space for separate and secure waiting rooms. Courtrooms should be large enough and configured in such a way to avoid contact between victim and defendant, and also to allow for special measures to be put in place. And when I'm dealing with any case of sexual violence, the first things that I'm looking at is, potentially prioritizing the case. I'm always very sensitive to the needs of the victim, which I'm going to come onto in a moment, and also looking at protective measures. What measures do we need to put in place in order to make sure the victim is safe, and certainly to create an environment in which they can give their best evidence. What I will normally do when I'm looking at special or protective measures, these are called different things in different jurisdictions. We can look at, for example, screens, video link, and restrictions on cross-examination. Safety at court in proceedings is critical. If the victim does not feel safe, it's unlikely that she will be willing to participate. And if she does in an unsafe environment, the quality of her evidence will be significantly reduced. And obviously, it's important that when the victim is giving her evidence in court, that she doesn't feel intimidated in the way that she gives her evidence. Judges can consider a range of measures to enhance protection, and these may include requiring physical separation of complainant witnesses from defendants, minimizing victims' level of fear during the hearing, and protection from disclosure of a victim's identity. And obviously, as judges, we must strive to, where possible, avoid the risks of secondary victimization. I'm just going to have a look at the substantive hearing. Remember, gender equality is a fundamental human right. It's an essential aspect, an essential aspect of gender equality is equal protection of the law. And the operation of harmful gender stereotypes in decision-making violates the principles of substantive equality by denying individuals protection based on irrelevant considerations, and by denying victims the capacity to be judged on their own circumstances and experience. And that's what happens when we stereotype and we generalize. Judges, I suppose I give the focus here on judges, but I think all parties have an obligation, particularly during any pretrial conference, to address these types of issues and how the evidence is going to be given, what challenges, if any, the victim faces in terms of giving their evidence. But when we're dealing with gender-based violence and discrimination, the judge does have a role to play in ensuring that the court offers equal access. The rights of the accused and the victim are both important and should be enforced on an equal basis. There may, however, be cases where these rights are incompatible and need to be balanced. Finding the right balance between protecting victims and ensuring due process rights of the accused, I recognize is not always easy. And it's important to acknowledge that trials can become so intimidating or intrusive as to violate a victim's constitutional rights. Therefore, the judiciary should consider ways to ensure that court procedures and practices are less traumatic for victims. And it's incumbent upon the judge to balance the right of the accused to a fair trial, including the right to examine witnesses and the right of the victim to be treated with dignity and respect, and afforded the opportunity to give her best evidence, unhindered by threats or intimidation. And judges often make the mistake of thinking that in order to be fair, they have to apply rules of practice and procedure in exactly the same way, whether it's for defendant or for victim. And that, in my view, is not correct. Sometimes the practice or procedure needs to be adjusted to meet the standards of fairness. But of course, checks and balances must always be in place. And I'll give you an example from the UK. And to be honest, I don't know whether you have a similar practice in Turks and Caicos, but in the UK, a defendant, if a defendant is unrepresented, he is not able, or he's not permitted to cross-examine his alleged victim. And so what would happen in England is the judge would normally appoint counsel to represent the defendant, either for the entire trial or for that part of the trial in particular. So at the point where the defendant has the right to cross-examine the victim, and independent counsel would step in, and that counsel would deal with the cross-examination, and not the defendant. And I think the reasons for that are pretty obvious. That you know, what we don't want is for the victim to be so traumatized by the process that we deny her basic rights. But also, of course, we want the victim to be able to tell her story without being intimidated during the process. And I can only imagine how difficult it would be if somebody has had the courage to come to court to give evidence about a sexual assault, and then have to face questions from the person that she accuses, and be taunted by him as part of the process. And that would inevitably create further traumatization. The judiciary, in the performance of its judicial duties, must recognize and of course appreciate the harmful impact of gender stereotypes. And we need to identify and use special measures to facilitate the victim's participation. When I'm having a pretrial conference, I normally expect the parties who are going to be appearing at trial to attend the pretrial conference. And I normally expect to see an experienced prosecutor, or a prosecutor who is experienced in dealing with sexual violence cases. And if the prosecutor doesn't raise with me the issue of protective measures, then of course I will raise them. And you know, in most cases of sexual violence, there will be a need for some form of protective measures, be it use of screens, giving evidence by video link, playing a pre-recorded police interview, sometimes even removing the defendant from court, depending upon the defendant's behavior in court. And when interacting with victims of sexual violence who are traumatized, judges can consider strategies that, in my view, would promote a gender-sensitive and victim-centered approach. And as judges, we need to promote the victim's right to be heard, treat the victims with dignity and respect, understand possible feelings of shame, understand how court proceedings sometimes reinforce feelings of powerlessness and anxiety, understand displays of emotion, consider how gender-based violence may affect different women to different degrees or in different ways. Avoid making inferences from the victim's apparent emotional state and assumptions that are primarily based on inaccurate beliefs about how victims should react. And avoid assessing credibility of the victim by making inferences solely based on the way that she reacted, or I suppose our perception of how we believe a sort of irrational victim would behave. And it's important as judges to remember that traumatized victims behave in completely different ways. I have had victims appear before me who have been very calm and very collected in terms of the way that they have presented their evidence. And I have equally had victims who understandably have been on the verge of hysteria when giving their evidence. So, you know, victims, and I don't want to sort of trivialize this, but victims do come in all shapes and sizes. And it would be very wrong, certainly for the judge, to take a view simply based upon the way that the victim appears in court. Now, it's important for the judiciary and for the court service to create conditions that enhance the ability of victims to give their best evidence. In England, we constantly talk about best evidence, but you know what I mean. We want them to be able to tell their story clearly and accurately and hopefully in some form of chronological order. And we need to ensure that the complainant is comfortable or as comfortable as she can be in the circumstances. That may involve changing the aesthetics in the courtroom. It may involve allowing somebody to sit with the victim as she gives her evidence. It would almost certainly involve the judge and the prosecutor objecting, or the prosecutor objecting and the judge dealing with issues where, for example, there are needlessly repetitive, irrelevant, or humiliating questions that are being put. Judges need to control defense tactics by focusing on issues of relevance and allow the victim to seek clarification on issues, not simply to be sort of bamboozled by a string of aggressive questioning. And it's also important to take necessary breaks during the giving of evidence to make sure that the victim feels as comfortable as she can be. Relevance often comes up, and it's often a matter that judges need to deal with in sexual and gender-based violence cases. Obviously, prosecutors need to be alive to these issues as well. Consider whether questions that are being put by defense counsel in cross-examination are relevant. If not, the prosecutor or certainly the judge should intervene. I've observed in trials in sexual offense cases where during cross-examination, defense counsel have asked if the victim was wearing a bra on the night of the assault, if she'd been drinking, if she'd been acting flirtatiously, whether she had dressed provocatively, if she had been walking home late at night and was therefore basically asking for it. So that questioning is very rarely relevant, and prosecutors and judges need to sort of step on that, when it happens. Admissibility is usually around relevance. I'm going to give you some examples. And this is, I suppose these are examples of negative approaches concerning sexual history evidence. This will differ from jurisdiction to jurisdiction. So allowing evidence based on the myth that unchaste women are less worthy of belief, in other words, they are less credible, or that unchaste women are more likely than chaste women to consent. It's not uncommon for the defense to make and for judges to allow submissions about the existence of continuous consent simply on the basis that the parties are in an intimate relationship. If the victim made previous allegations of prior abuse that did not result in conviction, defense counsel may sometimes unfairly use this to imply the victim has a tendency to lie. Sexual history evidence also has been used to demonstrate sexual inactivity. And this has been determined admissible by judges to allow the defense to argue that the complainant was more likely to have fabricated the allegations. And the myth advanced here is that women who were previously chaste are more likely to fabricate complaints. Another troubling use of sexual history evidence is defense seeking to admit evidence that the complainant had been sexually abused in the past, and that because of this abuse, she had a disordered sexual perception that could lead to misinterpretations, overreactions, and the making of false accusations, and therefore put her credibility at issues. So judges should intervene to prevent the introduction of irrelevant evidence based on the victim's prior sexual conduct and consent. And avoid the use of myths and these harmful gender stereotypes when determining matters around admissibility. These are sometimes not easy questions around admissibility of prior sexual history. And I know that the law in different jurisdictions does differ quite markedly on this. Victims' failure to report an assault. This is a common theme amongst defense counsel. At trial, a delay in disclosing an assault is often perceived as a discrediting factor to the credibility of the victim. There is an assumption that some women lie about rape, and we are quick to form opinions, often based on stereotypes and prejudices. Because credibility is the determining factor in most sexual assault trials, a lack of recent complaint often serves as an argument that the defendant should be acquitted. And rational ideals are frequently used by defense counsel to suggest that delayed reporting is somehow suspicious, while immediate reporting is considered to be the ideal. And questions are sometimes raised as to why didn't she call the police straight away? And this is based on the mistaken belief that a woman who is sexually assaulted will disclose the assault at the first opportunity. This idea is premised on this mistaken belief that an ideal victim, of how an ideal victim would or should behave. And I've already touched upon this, but fighting back is another common myth. And this fails to recognize that there are many reactions to sexual violence, including the victim wanting to wash after an assault or disclosing to her family or friends first, and only reporting to authorities after they feel supported. And so judges and prosecutors, I would suggest, might find the following useful. I mean, intervene to prevent cross-examination about the victim's credibility based on the introduction of delayed reporting. There are often reasons for this. And avoid the use of myths and these harmful gender stereotypes in assessing the lack of physical evidence due to late reporting. This isn't fatal to a case. It clearly goes to credibility, and that's going to be a matter for the judge or for the jury, at a later stage. And judges should avoid using language in judgments that implies the victim is blamed for delayed reporting. There are many, many reasons why victims do not report promptly. And, judges should provide detailed legal reasoning as to why no adverse inference should be drawn solely from a delay in prompt reporting. Avoid adopting stereotypical myths. This is important for the judge in particular. The ideal rape involves force or use of violence, physical injury. If the victim didn't fight back, she consented. Real rape would be easily corroborated or substantiated by physical evidence, and lack of medical evidence makes the victim's testimony intrinsically unreliable. Those are all myths, and I've dealt with most of those already. I've also dealt with this, but this is such an important issue, and I see this so often that it's worth mentioning again. There is a tendency of over-reliance on forensic evidence based on the assumption that there is a simple truth to be uncovered, and that empirical or scientific evidence is the most legitimate method of finding it. In terms of medical evidence, there are three critical things that you should take away from this presentation. Number one, medical reports should not conclude whether rape has occurred. Medical reports should simply describe the examination and findings. The doctor has no business saying whether in his or her opinion a rape has occurred, or even that the injuries are consistent with rape. The doctor should simply report what he or she has found on an examination. Secondly, a doctor cannot comment on whether the activity was consensual or otherwise. Again, it's purely about examination and findings. And thirdly, it's very important to remember that rape is not a medical condition. It's a legal definition. And judges in particular should be sensitive to the way, or to the many reasons, I suppose, why a victim has not undergone a medical examination. And be aware that lack of physical injuries do not mean violence was not used, or indeed there was consent. And remember that forensic evidence should not be required in order to convict. I'm almost at the end, actually. Judicial decision-making, judgment writing. I want to say a few words briefly about judgment writing in cases involving sexual and gender-based violence. And this isn't intended to be a mini course on judgment writing. When writing a judgment, judges should look at the dynamics of the form of violence that was used, intimate partner violence, sexual violence, stalking, etc. Identify situations of power between the parties, and what was the power imbalance, depending on, obviously, on the context in which the violence took place. Avoid shifting from a focus on the actions and state of mind of the accused to an interrogation of the victim's state of mind and what she did and did not do during the incident. And in assessing the credibility of the victim, judges need to understand the context of gender-based violence, the effects of trauma on victims, and also the power dynamics that, I suppose, characterize the use of such violence. And again, I've touched upon all of those, but I just want to mention those. In assessing the facts, identify and expressly reject any myth or harmful gender stereotype, and avoid language in judgments that uses or relies upon either myths or gender stereotypes. I'm adding this for completeness. Occasionally, relevant substantive or procedural law is found to be in conflict with constitutional and international law on non-discrimination, where as a party or as a judge, this has been identified, you should apply the correct constitutional or applicable international law, particularly relevant for judges because they should do this in their decision-making and then explain that in their reasoning. And in particular, judges should consider whether the domestic law is biased against women, and determine the differentiated impact of the law on women and men, and do not apply discriminatory interpretations of procedural rules without challenging them in the courtroom. And I know that you're all probably aware of the case of Chandler and the state, but that deals with this type of scenario, and I'm sure many of you will know that case far better than I do. And judges should also look at whether there's a relevant international law that can be applied. Precedent, look at the case law, national as well as comparative from other countries. It's also useful that promote substantive gender equality without condoning myths and the gender stereotypes. And apply an interpretation of the law that promotes substantive equality and is not based on myths or those gender stereotypes. Reasonable doubt does not mean the absence of any doubt. Identify and avoid judicial reasoning based on myths and stereotypes. Critical. Focus on the proven facts rather than inferences by way of some generalization. And before inferences are drawn, the question should be whether the underlying generalization is misleading, discriminatory, and one that should be eliminated from the fact determination process. So look, that is a very general overview of sexual and gender-based violence. When I've done this presentation in the past, it's been for judges and has been sort of quite different to this. Unfortunately, it's not as interactive or it's not at all interactive. And that's a shame, because I think sometimes when you have this sort of exchange of ideas, it makes it sort of far more fruitful, not only for you, but also for me. And I suppose the other problem that I have whenever I'm approaching a presentation like this is that I do not know my audience. And I do not know your level of skill and experience in dealing with this type of case. And so therefore, because of that, it's been sort of rather generalized. And I apologize to those of you who deal with this regularly, and you know, much of what I have said was not particularly interesting. I hope that for some of you at least, this was quite a useful presentation. I know we're running out of time. I don't know whether there are any questions for me. I'm happy to answer any questions on this, or if any of you just have any views you want to share. Or if you have any questions generally about case or trial management, then I'm happy to answer any of those questions. So I will hand back now to Mr. Emmanuel for him to take matters forward.
Good morning, everyone. Thank you very much for that very thorough presentation, Judge Simmons. So now we invite questions from the audience.
Yes, just one question.
Yes.
Yes.
Yeah.
I just have one or two questions or comments, really. I have dealt with such matters at different stages. As a prosecutor, as a high court judge, and also as an appellate court judge. The issue of recent complaints arises very often. And it's an issue which defense counsel most times ponds upon. I recalled a case where the complainant complained 6 or 7 days after the rape occurred. And she said she was, in essence, trying to process what happened. It was a date rape. She met the defendant on the Tinder. They went home to her home. They had a few drinks. They looked at some movie, American Pie, on her laptop. Next thing she knew, she was on the floor, bleeding, and the defendant was asleep on the sofa. She said she felt kind of funny after she had a drink or two, but she felt embarrassed. She was in fact virgin intacta. And she complained to a friend about 7 days after. The issue had arisen as to why she took so long to complain. But as you indicated, Justice, various factors can be advanced as to why the victim delays in complaining. And the judge, of course, would have to give the jury the appropriate directions on recent complaints. Even on the issue of consent in rape cases, there was a case where the victim, recognizing that she was unable to prevent the assault on her, offered the defendant a condom. You see? Now you might say, well, is this consent? No. But she felt he was unable to prevent the outrage. And for her own safety, offered a condom to him. very interesting, but this should not be interpreted to mean that she was consenting to the offense. She just did not
Yes.
have the power to resist physically, and she knew her strength and his strength, and therefore took a safe way out of it. Another instance concerned a case where an incest case, where the defendant raped his sister, and she kept quiet for about 2 days, made no complaint at all. But she changed her WhatsApp status, and the change aroused the curiosity of a brother of hers, who called and asked her, "Why have you changed your status to a hangman's noose?" Then she revealed to him what transpired, that her other brother had raped her. You see? And this set into question the issue again of recent complaints. So the victim has a whole range of reasons as to why they may not complain at the same time. But I think the appropriate directions by the judge would obviate any injustice, or prejudice occasioned by that delay. That's just a few comments on matters I have dealt with.
Yes.
One
Thank you very much.
Though, before I end, you spoke about the gender and sexual based violence, and the very wide definition which is encompassed therein. Does this wide definition hinder or imperil or assist the sensitivity of judges to the issues raised there, or even the prosecution of such offenses?
In terms of the definition being too wide, or
indeed too wide, yes, too wide, particularly where there's a case where our laws define rape, define incest, and such matters, and it's a very wide definition. Would the prosecution or the judge take into account issues like the power dynamics between the complainant and defendant?
Yes. Yeah, I guess it depends on the jurisdiction, but they should. So if there is a serious imbalance or a significant imbalance of power, and that the perpetrator uses that imbalance to effectively force the victim to do something that she does not wish to do. So there's no, then of course, yes, that would fall squarely within the definition of sexual and gender-based violence. And of course, the definition, as I said at the beginning, the definition is actually quite imprecise, because it uses the word violence when in fact what is meant and intended by the definition goes way beyond what we typically consider to be violence, and includes other forms of force. So, for example, what's considered to be sort of financial violence is sort of withholding access to funds. It's that sort of coercive, controlling behavior that often sort of falls within that definition. So it is very wide, and of course some jurisdictions interpret it sort of fairly restrictively, whilst others are fairly imaginative in terms of what they consider to be included within the definition. But yeah, I mean, late reporting is a huge problem. I did 8 trials last year on serious sexual assaults, and because of the way the justice system works in the Falkland Islands, most of those cases come before a judge alone. It's only in the case of penetration that we have a jury. And so most of those cases came before me. And I mean, I had one case where the victim was on her phone within about 45 seconds of leaving the house where she was assaulted. That was her first report. And then she went home. And then there was a slight delay because she was very traumatized. But then, of course, her family realized that something had happened. And then she eventually told her grandmother. And then she went to the police station. So she then went to the police station with her mother at about 1 a.m. in the morning. So we had the first report within a minute of leaving the house. We had the second report probably about 5 hours later. And then, of course, defense said, well, but the police didn't take a statement from you at that stage, which was correct. The police officer to whom she reported the alleged assault or the assault, she took quite a lot of detail down, but at 1 o'clock in the morning, took the view that it wasn't appropriate to be taking a very detailed statement from a clearly traumatized teenager, and therefore decided to put the matter over until the next morning when an officer who was experienced in dealing with this type of case would be on duty, and that officer would be able to take a full audio video recorded interview. So but then, of course, police were criticized during trial for that delay, which I thought was entirely reasonable. But you're absolutely right that obviously when you have a jury, you have to, as the judge, you have to give very careful directions to the jury regarding any perceived or actual sort of delays in reporting.
It's just one last matter. It's a case of incest, where a 15-year-old child, a daughter, complained that her father had been having sex with her. The police were involved. She was interviewed, gave a statement. But she came to the conclusion that her father required counseling, and she had no intention or desire to see him in jail, and went further to state very clearly that if he is charged for incest, she will commit suicide. She'll kill herself. And on 2 occasions, she had fled home because of the same sexual assault. Now, how does one, in fact, deal with that matter? Do you proceed to charge on the evidence available, risking the possibility or probability that you might effectuate her intention?
Yes.
It's ticklish sometimes, you know.
Yeah, they are very difficult decisions sometimes that you have to deal with, and obviously they are fact and case specific. And I mean, I'll give you an example. Recently, a few weeks ago, I sentenced somebody to a term of imprisonment, and they had, in the days leading up to the sentencing, had attempted to commit suicide twice. And the probation service said to me, you know, this is a serious concern that we have, that she may, you know, be successful next time. And obviously that's something that I have to, you know, to consider. And it's something that as a judge, you know, it does weigh heavily on your mind as to whether this is something that should sort of obviate against a custodial sentence. But, you know, at the end of the day, in that case, a custodial sentence was entirely appropriate. And so I handed down the custodial sentence. But the prison service were fully aware of the risks. And so they have her being very, very closely monitored. And she's receiving counseling and support from other agencies. So, you know, they are tricky decisions. And another judge in the next court may have taken a completely different view to the one that I took, and may have decided that, you know, given that, it was more appropriate to try and find some other way of dealing with this case. So you know, they are really tricky cases. So, you know, you're right. They are
Yes.
sometimes create huge
yes, I
problems
chose
for-
in this case as the prosecutor
Yes.
to refrain from further action because I felt
Yes.
satisfied that she was quite serious and would have committed suicide.
Yes.
Difficult one.
Yes.
Yes. Yes.
Yeah. No, I
Thank
agree. I agree. Thank you.
Thank you very much, Justice Batiste. I'll acknowledge a question from the Learned DPP.
Yeah, thank you, Mr. Emmanuel. Judge Simmons, this is quite outstanding, I must say. Quite an eye-opener. It's not as if we've not had this in one or two training sessions, but I am grateful that we have this forum, JEI 2023, to have you deliver such, outstanding, make a presentation of this nature. It is quite inspiring to know that the plight of victims of sexual and gender violence, at least worldwide, is getting traction and attention of the world. Down in TCI and in the Caribbean generally, I think you made quite a very strong point in relation to social cultural myth and what people, the community think about. And as you were sharing that, my mind went to two things. One was a prosecution I did about 12 years ago of a woman that has been a subject of gender violence, had been battered a number of times by the husband. And in a small community, one of the islands we have here. And the third time it happened, at least the one that she reported, she almost died. And then when she came out of the hospital and was supposed to give evidence, and she did, she actually finally, after some persuasion, because it's just a small place and families get involved in all of this, one way or the other, the dynamics are just unbelievable. And the woman just survived, and she is reluctant to come and give evidence against the husband. But at the end of the day, she entered the witness box. You want to be careful, again, how you deal with somebody like that, with the trauma she had gone through. When she did, and I was taking her through examination in chief, and at every point when she got to what the man did to her, she kept mute. She wouldn't say anything again. And I asked the judge whether we can take an adjournment. We did that 3 times. This is magistrate court now. We did it 3 times, but in hindsight now, I can see that the magistrate was so knowledgeable, sensitive, and he basically was flowing with me in terms of the need to bring out that evidence. And when he adjourned the 3rd time, he said, listen, let me read something to you. You have given your statement to the police. You have sworn to give your evidence, and you are before me. If you don't give your evidence fully the way you have, you ought to give it, your best evidence. If I find out that you are hedging or you just want to stop, I will imprison you. Now and the law makes provision for that, actually, the magistrate court's ordinance. And so we took another adjournment. By the time we came back, the accused person pled guilty. And so, but it was just an experience that listening to you 12 years ago, and in a community where they have not been so sensitized as we are now, it looked like if I was alone pressing for the woman to give her evidence, and that between myself and the judge, we were basically re-victimizing her. So
Yes.
in a sense, you tend to kind of feel guilty. What was I trying to do? Do I tell this woman to walk away? I was looking at the pictures, and that's the woman that would have died. And this was not the first time. And the husband was just there, feeling unconcerned, and probably was going to do it again. And so he went to jail for, I think, 2 years or so. And of course, by the time he came back, shortly after that, he died, but not as a result of that. But it's a particular prosecution as you speak this morning that I cannot forget. The other thing is TCI has moved on in terms of, not moved on, we have I think we are sensitizing the community more now. Incidentally, next month is all dedicated to Gender Violence Awareness Month. And interestingly, it is being spearheaded by the Social Development Gender Department. And they have incorporated my office through the Victim and Witness Support Unit. And we have also involved the judiciary. As a matter of fact, the Chief Justice has already assigned somebody from the judiciary to be part of what is going on with the awareness. So it's happening at that level of the community, and it is important, Judge Simmons, because you may not, we don't have a situation where statutorily you are to take on judge alone trial in a rape case or gender violent case that comes to Supreme Court. So you still have the jurors there, who are, as it were, still struggling with the myths and with the irrespective of the directions that might be given. So the kind of exposure we are having in this training and in the sensitization is taking a little bit, may take some time to reach out to the potential jurors who still come in there with their mind closed, literally. And it gets worse when you have a defense counsel who is not sensitive and who doesn't really care. It's all about my client, and I don't care anything else about a victim. And so he tends to justify that approach, even though he knows that he is an officer of the court first and foremost. And that brings me finally to this point. I wonder whether the provision we have in the current rules of UK, that's, I think, is rule 3.9 of the, at least the 2015 version, that makes room for case preparation and progression. We also have it here, but apparently the Chief Justice practice direction in UK is encouraging what they call the ground rule discussion, and as a good practice, not necessarily involving intermediaries and when young persons are involved in giving evidence. But I in those pre-hearing ground rule hearings, it might be necessary. I'm suggesting, I don't know whether that is done in practice, to if you like, delineate what kind of questions will be asked in relation to the particular witness. And then a document basically is informally agreed, if you like, between prosecution, defense, and the judge as part of his case management work. And at the end of the day, the defense now knows there are certain questions that should not ask of this victim. I'm wondering whether in our jurisdiction we can go that far. And I think we can, in my view, we can, once we are sensitive to the kind of victim of rape and victim of sexual and gender violence. at the bottom line, actually, is sensitivity in the community, sensitivity at the bench, the prosecutors, and of course the defense. We have attended, a number of us, including the judiciary, I'm aware, have attended seminars and training on these specialized areas. What I don't know is whether and how we can involve our defense team to also attend similar training so that they know what the boundaries are and sensitive to, knowing that, as Justice Taylor Alexander was saying on Monday, let it not just be criminal justice operators, just there on our own. We are not victim focused in any way at all. And we just carry on as if we are different from the community and what is happening in the community. So thank you again for quite an outstanding presentation.
Thank you very much. Yes, I mean, certainly when it comes to sexual and gender-based violence, there does have to be sort of a holistic approach. So it starts with, I suppose, in terms of interaction with the criminal justice system, it starts with the police. So we have to have in place all of the measures to ensure that when somebody reports to police, that they will have a sympathetic ear and they will have somebody who is trained in dealing with this type of event. And so they know what evidence to gather and how best to go about that. And then, of course, you have to have prosecutors who know how to deal with these cases, who are equally sympathetic. So, and it goes all the way up to the judges. And my view remains that we should have judges who receive specific training in how to deal with sexual and gender-based violence cases, particularly in terms of, the measures that are available to the judge in terms of just protecting the victim in the lead up to the criminal proceedings, in terms of any sort of orders that need to be made there. But then also in terms of special measures that might be available for the court to ensure that the victim is able to give their best evidence, but also then making sure that throughout the criminal trial, that the measures are in place to ensure that the victim is as comfortable as she can be when giving evidence. But obviously the judge also needs to be sensitive to all of the issues around, for example, late reporting, so that when they are giving directions to the jury, they fully understand actually what the rationale is behind the direction that they are giving. And as I say, victims react in completely different ways. I think coming on some of the other points you've made, which are all very valid, I think we are seeing a change towards sort of equal rights for women, and it's very long overdue, and it's obviously moving faster in some communities than in others. And I think all we can do is to create an environment in which women and girls feel that, if they report an assault, that they will be treated, that it will be taken seriously, and that they will be treated appropriately as part of the process, because I think so many people have put off reporting this type of event because they're afraid of how they will be received and the further sort of traumatization. And of course, a lot of victims simply want to forget about what has happened to them. They don't want to have to relive it over and over again, to relive it to the police, to relive it to the prosecutor, to then have to go through a trial when they have the perpetrator in court. So, I totally understand why a lot of victims don't report. And And, you know, there are all sorts of reasons why for late reporting, which I won't go into now, but, you know, but the idea of this presentation was simply to sort of try and touch upon some of the issues, so that at least we can all be thinking about the challenges, and then I suppose within our own jurisdictions try to come up with ways to address them.
Thank you so much, Judge Simmons. Just before I hand over to Ms. Tanya Carter for vote attempts, I'd just like to read two comments from the chat. One is from the Honorable Justice Laban Jackson, who indicates that here in the Turks and Caicos Islands, we do have a specialist unit for these reports, special measures, ground rules, and the use of intermediaries. And the second is from the Honorable Justice Rajnath Lee, Justice of Appeal of the Caribbean Court of Justice, suggesting that judicial officers may find useful the revised guidelines for sexual offense cases in the Caribbean, which have been developed and published under the Juris Project.
Okay, good.
So thank you so much for your presentation. And I now hand this over to Ms. Tanya Carter, the Executive Director, for a formal vote of thanks.
Thank you very much. Thank you.
Good morning, everyone, and good morning to Judge Malcolm Simmons. Judge, we say thank you this morning for your very enlightening presentation, which has helped us in becoming more keenly aware of the nuances of this very sensitive subject. We recognize the significance of such a very live topic in our society at this time, and your presentation has given much guidance to our judicial officers and stakeholders alike on how to treat with protecting the human rights of persons who have been victims of or who have experienced sexual and gender-based violence. We take to heart the guidelines and advice you have provided to us, and in particular to the judiciary, on how to effectively and efficiently case manage matters of this nature. To all our attendees, we say thank you for your attendance, your participation, and your contribution in this morning's session. On behalf of the Chief Justice of the TCI and the Chairperson of the JEI Committee, as well as the members of the JEI Committee, we say thank you once again. I now hand you back over to Mr. Emmanuel to close off this morning's session.
Great, thank you.
Thank you very much for everyone for attending. This brings this morning's session to a close. We'd ask before exiting the Zoom meeting, if everyone can please complete our feedback surveys so that we may improve future presentations. We look forward to your attendance at this afternoon's session. Thank you very much, Justice Simmons, and thank you everyone for attending.
Thank you very much, everyone.